Right now, at this very moment, there are at least 3 separate legal developments happening across the United States that could make things you currently own completely illegal, get your gun purchase denied at the counter, or strip you of your Second Amendment rights entirely. And the most dangerous part? Most gun owners have absolutely no idea any of this is coming. I am going to break down every single one of these developments today, what changed, when it takes effect, which states are affected, and exactly what you need to do right now to protect yourself. Every fact in this video comes directly from the Federal Register, the ATF's official rulemaking documents, the Colorado General Assembly, California Assembly Bill records, and verified legal sources. No opinion, no exaggeration, just the law as it actually stands today. Let's start with a federal rule change that went into effect on January 22nd, 2026, and most gun owners still don't know it exists. The Bureau of Alcohol, Tobacco, Firearms, and Explosives published an interim final rule in the Federal Register titled, Revising Definition of Unlawful User of or Addicted to Controlled Substance. This rule amends Department of Justice regulations to update the definition of who qualifies as an unlawful user of or addicted to any controlled substance, a category of persons who may not possess firearms under federal law. This definition was originally established in 1996 to facilitate operation of the National Instant Criminal Background Check System. Here is what that means in plain English. Under federal law, specifically 18 U.S.C. Section 922G, 3, anyone who is an unlawful user of or addicted to any controlled substance is prohibited from possessing firearms or purchasing one from a licensed dealer. Now here is the part that affects millions of Americans. And this is the part nobody is talking about. The previous regulatory definition, dating to the mid to late 1990s, allowed authorities to infer unlawful drug use from single incidents, such as a failed drug test, a drug-related conviction, or an admission of drug use within the previous year. In fiscal year 2025, the National Instant Criminal Background Check System denied roughly 9,163 firearm transfers under the drug use prohibition. Of those, about 4,364 denials were based on single-incident inferences, one admission or one positive drug test within a year. Think about what that means. Nearly half of all gun purchase denials under this rule were based on a single incident, not a pattern of use, not an addiction, not a criminal conviction, just one positive test or one admission. And for people in states where marijuana is legal, this has created an extraordinary legal trap. Marijuana remains illegal under federal law. The new rule requires regular, current, ongoing use rather than a single past incident. But current, regular marijuana users remain federally prohibited persons. The rule does not categorically exempt state legal marijuana use from the federal prohibition. It also does not state whether it would recognize marijuana use that is prescribed by a physician in compliance with state law. Marijuana possession remains illegal under federal law, even if it occurs in compliance with the law of the state or locality in which it occurs. So if you live in one of the 24 states where recreational marijuana is legal and you use it regularly, you are still a federally prohibited person. You cannot legally buy a firearm from any licensed dealer. And if you lied on your Form 4473 and said you do not use drugs, that is a federal felony. In fiscal year 2025, the NICS denied about 4,364 firearm transfers based on single-incident inferences. The ATF acknowledged that most of those cases were not pursued for further investigation, meaning thousands of people were denied guns based on a rule that the agency itself now admits was misaligned with how courts interpret the law. The comment period for this rule is open until June 30th, 2026. If you want your voice heard, this is the time. Now let's move to the state level, because what just happened in Colorado should alarm every gun owner in America. Colorado Governor Jared Polis signed Senate Bill 3 into law in April 2025. Starting in August 2026, the manufacture, sale, and purchase of certain semi-automatic firearms that can accept detachable ammunition magazines will be outlawed in Colorado. That will include AR-15 and AK-47 rifles, as well as a long list of their popular variants. Senate Bill 3 also affects tactical shotguns and a small number of handguns. Let that sink in. AR-15s, AK-47s, tactical shotguns, all of them banned from manufacture, sale, and purchase in the state of Colorado. And the clock is ticking. The law takes effect August 1st, 2026. The new law does not apply to recoil-operated handguns, revolvers, or shotguns. It also will not apply to gun owners who purchased any of the banned semi-automatics before August 2026. So existing owners are grandfathered in for now. But here is what most people are missing. There is a pathway to still buy these weapons after August, but it is not easy. To legally acquire a specified semi-automatic firearm after the law takes effect, you must apply for a firearms safety course eligibility card through your county sheriff, which includes a fingerprint-based background check. Then complete a state-approved basic or extended firearms safety course covering safe handling, legal responsibilities, and de-escalation techniques, and pass both a written and practical exam. Applicants must score 90% or higher on a test after completing state-mandated safety training. And if you think you can just drive to Wyoming or Kansas to buy a banned weapon and bring it back, think again. Coloradans will not be able to avoid the new restrictions by buying a gun in another state. Federal law requires firearms dealers to abide by the laws of the state where the buyer lives. Violating Senate Bill 3 is a Class 2 misdemeanor punishable by up to 120 days in jail and a fine, or both. Subsequent offenses, however, are a Class 6 felony punishable by up to 18 months in prison. Possession of a rapid-fire trigger device is now a Class 5 felony, punishable by up to 3 years in prison. Gun rights groups have filed a federal lawsuit challenging the law's constitutionality. The law includes exceptions for military, law enforcement, prison guards, and armored vehicle businesses, and does not affect guns that Coloradans already own. But until a court issues an injunction, the law stands, and August 1st is coming fast. If you think Colorado is bad, California already went further, and this one is already the law as of January 1st, 2026. Assembly Bill 1263 officially went into effect on January 1st, 2026. This is not just another minor update. AB 1263 introduces sweeping changes to how firearms are manufactured, how parts are sold online, and most importantly, who is allowed to own a gun. For many Californians, this bill creates a misdemeanor trap that could lead to a 10-year loss of firearm rights for crimes that previously did not carry such a heavy penalty. Here is the specific list of what now triggers a 10-year gun ban in California under AB 1263. Starting January 1st, 2026, if you are convicted of unlawful manufacture of firearms, meaning using a 3D printer or CNC milling machine to create a firearm without a proper license, you lose your firearm rights for a full decade. The same applies to aiding or abetting unlawful manufacture, which is a brand new crime created by AB 1263. It targets anyone who knowingly or willfully helps another person manufacture an illegal firearm. Even misdemeanor possession of an assault weapon or a .50 BMG rifle now triggers the 10-year ban. And here is the part that is catching people completely off guard, the online parts market. As of January 1st, 2026, any firearm industry member, including online retailers, selling firearm accessories, manufacturing machines, or unattached barrels to a California resident must provide a legal notice warning that manufacturing certain firearms in California is a crime. Many retailers are now simply refusing to ship to California altogether. Here is the national pattern that every gun owner needs to understand right now. Gun laws change frequently, and 2026 is shaping up to be another critical year for firearm legislation. Several states are considering new restrictions on semi-automatic firearms, magazine capacity, and ammunition access. New laws can affect how firearms are purchased, transported, stored, and carried. Colorado and California are not acting alone. Proposals in 2026 include legislation in Minnesota, Virginia, and New Jersey targeting semi-automatic firearms. Several states are proposing bills that would expand or revise how semi-automatic rifles, pistols, and shotguns are classified. And at the federal level, there is growing concern that the ATF may attempt to redefine terms like suppressor or frame or receiver to maintain control even after the Big Beautiful Bill eliminated the $200 tax stamp. Legal experts advise gun owners to stay vigilant by keeping an eye on proposed rules and Federal Register updates. So let me give you the 3 things you need to do right now, today, based on everything I just told you. First, If you use marijuana in any state, even a legal one, understand that you are currently a federally prohibited person under 922G. Free, if you are a regular user. Do not lie on your Form 4473. Consult a Second Amendment attorney. Second, if you live in Colorado and you want an AR-15, a K-47, or any semi-automatic rifle with a detachable magazine, you have until July 31st, 2026 to purchase one without going through the new permit system. After that date, the law kicks in. Third, if you live in California and you do any work on your own firearms, sell parts online, or help a friend with a build, understand that AB 1263 created brand new crimes that did not exist before January 1st. The 10-year gun ban is now triggered by misdemeanors, not just felonies. What you don't know can cost you. These laws are real, they're already in effect or just months away, and most gun owners across the country have no idea they exist. Subscribe, share this, and stay locked in, because the legal landscape for gun owners in America is changing faster right now than at any point in the last decade.